Let's start with the latest on the Kyle Rittenhouse trial. The jury will meet for day 3 of deliberations. This comes after the defense has requested a mistrial, claiming the prosecution withheld key video evidence. The prosecution, however, is denying those allegations. Watch.
To somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous.
Joining us now, constitutional law attorney Amir Benno. Also joining us, partner at the Bianchi Law Group, Bob Bianchi. Amir and Bob, welcome to the program. Thanks for coming on today. Bob, start us off. Does the Rittenhouse defense team have a case for a mistrial, considering this new debate over this drone video?
Well, they're going to have a number of issues for a mistrial over the drone video. As a former homicide prosecutor, one of the things that we always did was, before we had our trial, we had an evidence review with the defense attorneys to ensure they had everything in their file that we had in our file. And the fact of the matter is, it's not an even playing field. If the prosecution is in possession of something, the defense should be as well. Now, the judge will have to make a determination as to whether or not this was in bad faith or not. And it is kind of odd how these videos got to the lawyers in the first place. But let's add this to the compounded constitutional error of commenting on the defendant's right to remain silent while he was on the witness stand and disobeying a judge's order with regard to the admissibility of evidence that the judge had precluded. And I love this because I've been saying this for a while and everybody thinks I'm kind of crazy. The judge is reserved on these motions. My feeling is the judge is going to wait for the jury to come back. And if there's a not guilty verdict, then the judge does not have to respond to these motions. But if there is a guilty verdict, and before the conviction is entered into by the court, that's where I believe the judge is going to handle these motions. So the judge very well may say one or a combination of all of these things have deprived the defendant of a fair trial.
Wow. Okay. And Amir, of course, we're still waiting for the jury to reach a verdict. The fact that we are on day 3 of deliberations, what does that tell you about what's going on behind the scenes?
Well, that tells us that the jury's struggling over these elements. What they're looking to watch, these videos, it seems like they're really going through the requirements of self-defense. Now, the important thing that, we're reading tea leaves here, but you don't even get to the elements of self-defense if the prosecution was successful in convincing the jury beyond a reasonable doubt that Kyle Rittenhouse provoked these shootings. Because if you provoke it, then under Wisconsin law, you're going to lose your right to claim justification. So the fact that they're looking at these videos suggests that they're trying to analyze the timing of the shooting, the actions of the aggressors, and that means that they may have gotten beyond that issue of provocation, which would generally be good for the defense. But the fact that their mistrial request, the most recent one, is without prejudice, meaning that if it's granted that Kyle Rittenhouse could be retried, suggests that perhaps the defense team feels that the jury might be inclined to convict on certain counts. And therefore, they think that having a retrial would be a better outcome than having a conviction. And so they're sort of rejiggering their application to the court in light of that.
There are 5 charges that Kyle Rittenhouse faces at this moment here. Bob, based on what Amir just said, are there ones that you could eliminate or ones that you are more focused on he could be facing?
Look, I've been trying cases for 30 years, and I know it's a fool's errand to ever try to guess what a jury is doing. We do it, but we do it at our folly. So it's very difficult to make a determination as to whether or not they started with self-defense, whether or not they're going to lesser included offenses. There is a lot for this jury to consider. There's a lot of evidence. There's a lot of movement in the crime scenes because you have 2 separate crime scenes. You have very complex and, in my mind, very convoluted jury charges in the first place. The provocation charge that the judge put in, he gave that bone to the prosecution, but I don't see provocation in any way, shape, or form in this case because under the law, and the jury's going to read it when they see it, he has to be conducting an unlawful activity And even if he is conducting an unlawful activity, if they escalate force to deadly force, he's allowed to use deadly force in response. The facts of this case are he was the one being pursued, throwing rocks at him. He did not provoke the event. He got knocked down to the ground, hit with a skateboard, kicked in the face. The only question that this jury is going to have is whether or not his use of force was reasonable under the circumstances. I would not read into anything. I've had trials where I thought the jury would be out for days and they came back in 20 minutes. I've had trials where I thought they were going to come back in 20 minutes and they came back in 20 days, and I mean that literally. So you just don't know at this point in time what they're considering. Although last point, the prosecution scored a big point. They blinked, but they scored a big point when they asked for those lesser included offenses. That meant that the prosecutors were not confident that they could win the intentional murder counts, and they wanted to give a jury a lesser option so that they had a choice between not guilty and the highest charge. That, to me, says prosecutors are worried that they're not going to be able to convict them on the highest charge. So I don't think we can read too much into what the jury's doing right now. I think they're being deliberate and they're doing their job.
Okay. Again, the prosecution asking for possible lesser charges, the defense asking for both a mistrial and a mistrial with prejudice here. Amir, when you're in the minds of the jurors who've been asked to make a decision, a verdict on this trial here, you keep in mind there are people outside the courthouse. At this point in Kenosha, there are protesters right now gathering outside. How much of an influence does that have on the jury's decision that they might reach or their ability to come to a decision?
That's an unknown also, but certainly it doesn't help trying to encourage the jury to base their decision simply on the evidence that they hear in the courtroom and the law that the judge instructs them on. So the BLM supporters out there are clearly there to intimidate the jury into finding a particular way. There was a moment in time, I think yesterday, where they were sharing a pizza together, those who are in favor of acquittal and those who are in favor of conviction. But then some of these BLM supporters chased away and I believe dumped some soda on the heads of some of the individuals who were saying that Kyle Rittenhouse should be acquitted. They were trying to take bullhorns and shout them down, saying the people who were pro Rittenhouse, saying that the BLM supporters were there simply to intimidate the jury. So that's what they're there to do. And there aren't any security fences up there like we saw during the Derek Chauvin trial. So this is always a concern. We won't know, obviously, until the verdict is in, what effect that has. But I do want to make one point onto what Bob was saying before. We do know that they're considering the provocation, because provocation was the people's argument, the prosecution's argument, and that's the whole purpose of this video, this drone video, is to show that Kyle Rittenhouse pointed his gun at certain individuals, and by doing so, provoked everything that happened afterwards. The fact that that is the same video that the defense is saying they were not provided with, they were provided a compressed version of, the quality wasn't as good. And now the jury asked for and was able to review that in deliberations. That's a big issue, because without that video, who knows what the jury would decide on that provocation point. And so this is one of the legal questions that's tied in with the facts of this case that ultimately I think might be for an appellate court to weigh.
All right, we got to leave it at that. Our thanks to our legal panelists, Amir Benno, Bob Bianchi. We appreciate it, guys. Thanks so much.
Thank you.
All right, coming up.